So here we have a really old case, and it's really hard to find in the laws. I've seen reference to it in some of the old court case books, but it's nearly impossible to actually find this case in its fully written opinion. So this is from United States versus one Woodbury and Minot, page 76. And it says, where the United States own land situated within the limits of particular states and over which they have no cession of jurisdiction, that means the state did not cede any lawmaking power to the United States over these particular lands. He continues, for objects either special or general, little doubt exists, that means there's no proof, that the rights and remedies in relation to it are usually the same as applied to other landholders within the state. So this is talking about the jurisdiction, and this would be proprietorial interest only, because when you have a proprietorial interest, you have the rights that a regular person, a private person has when they go and they buy private property. So when the government bought some property from the state, or they um, somehow acquired, they didn't have to actually purchase always, but somehow acquired some property within a state, but they weren't using it for the purposes dictated in the Constitution. They were using it for some other purpose, such as Federal Reserve banks, or the United States back in the old days, 100 or more years ago, would acquire some land from the state for growing crops. And so the state didn't cede lawmaking power to all of these lands to the federal government. They kept it for themselves. So this would be federal lawmaking power over these federal lands in the state. So they had proprietorial interest only. And it says this term is applied to those instances wherein the federal government has acquired some right or little title to an area in a state, but has not obtained any measure of the state's authority over the area. So the state has to give up authority. So they don't just give up the land, but they give up the authority to make the laws for the land. In applying this definition, recognition should be given to the fact that the United States, by virtue of its functions and authority under various provisions of the Constitution, has many powers and immunities not possessed by ordinary landlords with respect to areas in which it acquires an interest, and of the further fact that all its properties and functions are held or performed in a governmental rather than a proprietary capacity.